A huge non-deeded road, as we saw before, divides my property into 1/3. I thought that this road corresponded to the depicted easement on the county map, as I pointed out earlier. And when I asked the seller, Mr. Haber, to tell me about the roads, he did not mention this road. However, Mr. Haber tried to set up a road association for this road with 5 families that live on the top of the hill while he owned the land, but chose not to disclose this fact to me. This now abandoned road that was being used by 5 families, the uphill neighbors, and it turns out that these 5 families are landlocked without the right to cross over my land. Surprise! My title report disclosed that these families had a right to use another easement, which we will look at, which was a dirt path for which a car could not travel. Therefore, I had no idea that these families were landlocked without the right to cross over my land. When I discovered this, I told the uphill neighbors, Conrad, Beauchamp, Castillo, that they could not modify the road and requested they quiet title so that I could use my insurance for legal assistance. However, instead of initiating a quiet title action, they instead proceeded to fully pave the other easement that was a dirt bike path only up to their uphill properties without my consent. I tried to obtain an injunction, and again the Santa Cruz court denied my request and allowed my uphill neighbors to completely modify an easement from an unusable dirt bike and abandoned easement to a fully paved road, which is 15 feet from my kitchen and bedroom windows, changing my house from a home in the woods to a home which is next to a major road. The fact that the court has continued not to require the illegal trespassing neighbors from having to bear the burden of initiating a quiet title action has led the uphill neighbors to represent to me, when I signed a settlement agreement, that they had a right to designate another non-deeded road called Andrea Lane to be one-way, possibly without contacting the owner of that land. But why should they? The Santa Cruz County courts shield trespassers from bearing the cost of surveys and litigations, while allowing them to completely change the characterization of an easement they had abandoned without my consent or right to discovery. Now, I could be open to more lawsuits regarding this Andrea Lane. So let's look at some video of this abandoned road. So again, while I'm talking, I purchased this property thinking that there were roads along the property line of the Sextons. However, as you can see here, all this road, which is a huge amount of road, which we saw on the maps, which divide my property into a third, none of these roads have any deeds at all. And the legal easements are non-developed land, which I also lose the right to use. So my property, 3 acres of property for which I have to drive up a one-way road shared with 9 families on a curvy road where you have to back up this curvy road when someone is coming the other way. I ended up with a property that I thought was in the woods to a property that is filled with roads, and a property where I have an easement 15 feet from my house that 5 families use on a daily basis. So I'm talking here, we're going to go up this easement. This easement goes up quite a ways, and on the right of this easement, approximately 100 feet down on the right towards the Bowden's property, is the legal easement, which is undeveloped. The Bowdens claim that they own all of that land, going all the way up the hill. We could fast forward this. So here I am walking up the road, up to if I walked all the way up, you would come into a big orchard where the uphill neighbors live. And here I'm pointing out some property line stakes where the neighbors claim a huge amount of the property parallel to this road. My intent is to abandon this other road, and I think a reasonable part of my damages is to pay for all that asphalt to be removed. So this is just a picture of the ditch, and we're going to swing around in a minute and see the property from another perspective. So hopefully this will only take a second. Thank you for your time. I'm seeking assistance in this lawsuit. I can't afford to pay someone outright, but I am pretty experienced at this point in this case. Someone attorney can hire me and review my work and be the attorney for record and let me do the majority of work with his approving things, help me out in trial, or any other kind of assistance if you know of anyone. Also, I really would like the appellate court to look at this and to, again, make a strong statement against the exclusive easement because it's being abused. If you are getting your neighbors to sign, somebody is getting a neighbor to sign a complicated deed without having their own attorney, without understanding what the deed means. An exclusive easement is ambiguous by operation of law. It can have 3 different meanings. So if a neighbor doesn't specifically state they are giving up their right to land through an exclusive easement, then it should not be enforceable in any way. It's being abused, and then innocent purchasers like me get stuck paying for $8,000 in survey bills, costly litigation. I have no way to get coverage, legal assistance through my insurance policy because the court has deemed that it is my burden to quiet title and has continually refused to force my neighbors to quiet title, which from a public policy perspective leads to tons of lawsuits over exclusive easements, and it encourages neighbors in the Santa Cruz Mountains to acquire land by trespassing without surveys, without deeds, and without even telling the owner of the land. So hopefully here we'll zoom around and you can see a different perspective of the land. It's in Felton, California. It's in the Redwoods. It's actually, you know, Henry Cowell is actually very beautiful. It's by the national park. So I guess that's enough for the abandoned road. So I have 2 more 5-minute segments, so let's cut and go to those. Thank you for your time.